Welcome back to another National Real Estate Exam Prep. And today we're going to talk about the transfer of title. More specifically, we're going to go over 5 questions with their explanations as to why they are the answer. The title to real estate passes when a valid deed is executed and mailed, filed and microfilmed, signed and recorded, delivered and accepted. Delivered and accepted. Title is not legally transferred until the deed is both delivered to and accepted by the grantee. Delivery can be made directly by the grantor or through a third party acting on the grantor's behalf. Both delivery and acceptance are required for the transfer to be valid. In order for a deed to be valid, the deed must be recorded. The grantee must sign the deed. The grantor must be legally competent. The grantee must be legally competent. The grantor must be legally competent. A valid deed requires that the grantor be legally competent, meaning they must be of lawful age and mentally sound. The grantee does not need to meet these same competency requirements. For the deed to be valid, only the grantor's signature is required. While recording the deed gives public notice of the transaction and helps protect ownership rights, it is not required for the deed to be legally valid. A deed must be signed by the grantee, the grantor and the grantee and two witnesses, the grantor. The grantor. For a deed to be valid, it must be signed by the grantors named in the document. The grantee must be identified, but their signature is not required. In some states, witness signatures may be necessary for the deed to be recorded. However, the grantee's signature is never a requirement for validity. A contract for deed provides for the sale of unimproved land only, the immediate transfer of legal title to the buyer at closing, the sale of real property under an option agreement, the conveyance of legal title at a future date. The conveyance of legal title at a future date. In a contract for deed, also known as a land contract, the seller retains legal title to the property until the buyer has fulfilled all contract terms, including full payment. The buyer receives possession of the property at closing, but does not receive legal title until the final payment is made. This type of contract can be used for both improved and unimproved land. Mortgagee title insurance policies protect buyers, sellers, land, or buyers and lenders. Lenders. A mortgagee title insurance policy protects the lender, mortgagee, against defects in title that could affect the enforceability of the loan. An owner's title insurance policy protects the property owner, as well as their heirs and devisees against covered title defects or claims that may arise after the purchase. All right, this was 5 questions with their explanations as to why. If this was helpful, give us a thumbs up and subscribe because we drop a new video every week to help you pass your national real estate exam.